website. All electronic devices, including mobile phones, should be switched to silent, and I ask all members of the public who have joined us not to interfere with the proceedings. For the purpose of the recording and transcript, I'd be grateful for everybody who speaks to ensure that they state their name and their role. I will start. My name is Deputy Tom Coles, and I am the Chair of the Regulation of Care Subpanel.
I'm Deputy Helen Miles, and I'm a member of the panel.
Deputy Jonathan Reniff, also a member of the panel.
Deputy Steve Lewis, I'm Minister for the Environment.
And I'm Francis Walker, Head of Policy in the Cabinet Office.
Welcome. So I'm going to start quite on the more narrow section of this, because we're going to ask a lot of questions, obviously, about hospital and ambulance services. But there is a section of these new regulations that come in which are slightly smaller in scope, and this is the case of the laser clinics and oxygen therapies. So I'm wondering, Minister, if you can outline why you chose these two particular services to include at this time.
Well, laser services are currently undertaken by some medical practitioners, as I understand, in the hospital, but I don't believe that lasers covered. We're not covering the entire concept of lasers, and I think lasers that are currently used will be covered, and lasers that are not won't be. I don't know, I probably haven't got that quite right. If I can just, maybe, Francis, you could remind me.
So the laser clinics are currently regulated under the nursing homes law, which is a 30-year-old law, used to be used to regulate nursing homes under, but currently it only regulates laser clinics. Those are clinics for class 3, B and 4 lasers that are not provided by medical practitioners or dentists. So that's currently covered under the law. So in order to enable us to repeal the old nursing homes law, which was kept on the statute book largely in case a private hospital was suddenly established, it would have provided some mechanism to regulate the service. But as we're now regulating all hospital services under this, it was deemed appropriate to move the laser clinics that are regulated, so they're not taken out of regulation under the law.
And what about the oxygen therapy services?
Well, we looked at this, and hyperbaric therapy will be included, and I think it was under discussion. Unfortunately, we have attempted to engage with the people that run the service over here. We haven't had any response from them at all. Officers continue to try to contact them. But it is important because, you know, this is important work, and I've got a list of all the things that could be affected. And, you know, claustrophobia, reversal, myopia, fatigue, headache, vomiting, but oxygen toxicity, and other things like sinus damage, ruptured middle ear, lung damage, things like that. This is an important service to get right, and it will be regulated. I don't know if you want to add any more, Francis.
Yes, it's just to be clear, it's the hyperbaric oxygen therapy, not just oxygen therapy, that would be covered under these regulations. It's just one service that was decided, given the nature of it and the risks and the fact that we weren't necessarily aware that there was hyperbaric. We knew there was oxygen therapy. We are in the process of we did contact the service during the course of the consultation. We didn't receive a response. We've had further a consultation with them. We're trying to meet with them later this month as well to understand if they do actually provide hyperbaric. Nevertheless, it was considered that this is the actual hyperbaric, not just oxygen therapy, which is sort of pressurised through a tube. This is in a chamber. It's felt that this was an appropriate time to regulate them. It's the ambition to regulate lots of services. It was just chosen that this was a service that could be regulated at this stage, given the proportion and the nature.
And obviously, oxygen that's not under therapy is used widespread throughout the community. You know, a lot of cancer treatment and other things will be used either through a machine which increases the amount of oxygen you're breathing, or you know, tanks of oxygen where you inhale it directly as part of your breath, but that's very separate. This is under pressure, and the combination of the pressure and the oxygen have a lot of consequences if they're not done properly, so it is important. Yeah.
Because we had a written submission from an oxygen therapy, and I don't know if that's the same people you were referring to.
Indeed, yeah.
That they mentioned that this isn't something that's then regulated in the UK. Is that correct? Or
hyperbaric oxygen therapy is regulated by the Care Quality Commission. That's certainly my understanding, and we've double-checked that since. So It depends. Services are regulated in different ways. Obviously, the Care Commission would have a lot of latitude as to regulate services in the appropriate way. So obviously the regulations here apply to children's homes and to hospitals. And so the nature of the regulation, the Care Commission tailors that. And I know you've spoken to them about how they decide to do that. So again, with the hyperbaric oxygen therapy services, they would do that in a different way. But nevertheless, they are regulated by the CQC. So we don't think there's a difference here in what we're proposing from what we've looked at.
Okay. And then the same sort of question leans back to the lasers and the laser clinics. We've had, again, some written submission about the use of intense pulse light laser treatments and whether there's risks of burns and injuries through these being improperly used. But I believe that those kind of lasers aren't in this scope of regulation.
I think we understand there will be a number of things where people feel they should be regulated. In fact, only this morning, Francis and I are discussing somebody who's applied for regulation quite unusually. We can't do everything at once, and I think we need to be very clear. If we were to say, right, we're going to regulate everything overnight, the whole system will become completely overwhelmed. So there is a structure. This is the third phase that we're going through. And this is quite a big phase, hospital and ambulance, obviously, and a few tiny little add-ons. But there will be more coming down the line. We know that medicinal cannabis, for example, is somewhere we need to go and want to go, but not right now. We want to get this bit done. We'll move on to the next, and there will be lots of little bits of next as we move forward with the whole project.
Well, just to pick up on that, you've chosen those two services to be included and others not to. Can you state what the criteria was to choose those and not, for example, medicinal cannabis or one of those other ones which are coming down the road?
You're referring to laser and hyperbaric as opposed to hospital? Yeah,
yes,
no.
yeah.
Lasers are already in use. Hyperbaric, as we've just explained, I think carries quite a lot of risk to it. But yes, we know that medicinal cannabis is somewhere we would like to look at. It will be the prescribing of medicinal cannabis in hospital will be covered under these regulations, so that it's the private sector that and I think it's just a question of trying to prioritise, and I accept the point. We did look at other things as well, but these two we felt were worthy of doing. Prison services was something else that we considered, and prisons, obviously, as you would expect, are inspected by Her Majesty's Prison Service, and a certain level of health is covered by that. So again, there's some sort of regulation. They're not completely unregulated. We will get there in the future again, I'm sure, but it was felt that lasers and hyperbaric was something that we could add.
Yeah, about the proportion as well. So clearly there are lots of other sensitive services. So there's minor surgery that takes place in clinics, there's GP surgeries, dentists. It was a question of proportionality. Clearly, we're asking the Care Commission to do a lot by regulating the hospital. When the State Assembly adopted this law, it was always very clear it would be a sort of phased approach so that services didn't fall over. So we took a risk-based approach and also a proportionate amount of looking at the work that the Care Commission would have to do. So the laser clinics was very specific to do with it's already regulated. We will just move those ones over. The hyperbaric oxygen therapy, they're distinct services. It's a service that we felt could be regulated. I mean, we didn't necessarily know there was hyperbaric oxygen therapy on the island, but we did, if it's there, we felt it was a proportionate service to regulate at this time. So that was the sort of rough criteria we followed.
So moving back more now to the hospital and ambulance service. Obviously, as you've already stated, that this was the 2014 law was always intended to be phased approaches. So what was the rationale for specifically choosing the hospital and ambulance services then to be this next phase?
Well, the rationale will have to be explained by Francis because it was before my time, but as I'm sure you'll know, this is work that came in December 22. The decision was taken that we would move forward. The funding was approved by government in those days, and I felt it was important to continue that work, and it was something that I wanted to do, just like the previous government had wanted to do. And I don't want to draw any assumptions. I could have a personal assumption. The hospital, obviously, the hospital and the ambulance service that goes with it. I felt that there was always maybe a feeling out there that they were already regulated, and people may well be surprised to hear that they're not. And obviously, the hospital is a function which just about every islander has to use at some point in time. They perform an enormously important function for islanders, and I think it's right and proper that the sooner we can do this, the better. They've had fair warning. The funding has been there for them to prepare and for the ambulance service, as the funding has, of course, gone to the Care Commission to get ready. I think we would have liked to have done this a bit sooner. We had a few challenges along the way, and certainly in the early days, 12 months ago, I was having quite detailed discussions with the Health Minister about the regulation of the hospital. He questioned the timing, especially given the fact that we were moving to a new hospital, and I was able to convince him, along with the new chair, who's very keen on this, to say to him, look, Minister, the most important time for an old hospital to be regulated is when it's going to move to a new one. On top of that, moving into a new hospital, you want to be sure that it's going to work as best as it possibly can. And the chair and the commission are here to help you with that. They're not here to bash you. They will be in a position to actually, hopefully, make it even better. So your move can be done in a better way, and the operation of the new hospital can be done in a better way as well. But as for the actual reasons for choosing hospital and ambulance as opposed to other things, I don't know, but I can only assume that it was so important it had to be done pretty much as soon as it could, and this was the earliest opportunity.
Yes, indeed. There was impetus behind it based on a public petition in early 2022, and that was then supported by the then Council of Ministers, and so then it was put forward to the incoming minister, Deputy Reniff, and there was a business case that went through, funding was granted, and that was the decision. And it was decided that ambulance services as well as hospital services, that would be an appropriate fit, because obviously the ambulance has a bit major interaction with the hospital. So you want to try and regulate sensible groups at the same time. So given that you didn't want to have a regulatory gap, if there was a question, well, actually the Care Commission can't look at that because the regulatory issue may have happened on the ambulance rather than actually in the hospital. So we wanted to close that gap. That's why we did ambulance with the hospital.
Okay. You mentioned there having discussions and conversations with the Minister for Health. How extensive were those? I mean, how frequently were they? What level of detail?
I suspect we probably met 2 or 3 times to discuss these things, and some of those, maybe 1 or 2 even of those meetings might have been unofficial meetings, if you like, but he certainly expressed a concern and in the early days that he felt it wasn't the right time. I think he felt regulating would be far more of a challenge than we feel it would be, and he needed to be convinced that actually he wanted to be helpful and a critical friend rather than somebody who just came in with a big stick and bashed the service. And I think there were a lot of people inside the service who were wary, but we were able to convince him, as I said, with the help of the new chair of the commission, that our job is to do a bit like scrutiny and be a critical friend and go in and show where improvements could be made. And yes, there may well be some times when the pointing has to be done where things need to be better or things have gone wrong and must be improved. But we very much hope that the Commission can work in tandem with the hospital to improve services for islanders and not come into conflict, which ends up in nurses and doctors being very wary. We want everybody to work together for a better outcome rather than be confrontational.
Can you explain the broader consultation that you did beyond just with the Minister in coming up with these regulations?
Well, Francis, over to you, I think.
Sure. So we ran a public consultation on the draft legislation. So I should say we never did a policy consultation because it was decided that the policy was set. The model had been adopted by the Assembly under the Regulation of Care Law in 2014. So that model of inspection with an online commission with standards legislation that was largely in place. So it was decided there's no point going back to first policy principles because we knew that was the direction. It was just taking a phased approach. So the policy, is it like legislation consultation, was very much a consultation on that law. We published that on the 8th of April, and the consultation ran for 8 weeks until the 3rd of June. Given the nature of the consultation, we weren't anticipating large volumes of feedback, but we did. We contacted all of the relevant services, and as I say, we published it and publicised the consultation. But as I say, it's a quite dry, obviously, because it's on draft legislation. But we tried to make it as engaging as possible, and we also did a smart survey as well. So we had 7 responses to the consultation via the smart survey and 4 email responses, and we also conducted internal meetings with not just internal meetings, although clearly most of the sort of substantive stakeholders are internal. They're the hospital and the ambulance service, but we also, and obviously the Care Commission as well, who were very heavily consulted throughout the process of developing the legislation all the way back to 2022 and devising the business case as well and working out the cost implications. And then we also contacted the services that we deemed we thought would be affected by the legislation.
Generally, I think everybody was supportive. The stronger support came for doing something about the duty of candour, which I'm sure we'll come on to, and also people under the regulatory standards bits were concerned about visitor access. And I think there was some sort of hangover from visitor access during COVID, the issues there that needs to be raised, and also the subject of access to medical records for people as well was another one that they focused on.
Yes, indeed. So we made some changes there to tighten up. So we were proposing those and just to tighten it up to make sure that those provisions that we put in couldn't be misused, as it were. So
Quite handy leads me on to my next question, which was about how those particular regulations were drafted. We wrote you a letter earlier in this process about it being considered to the use of by instead of from in the context is effective and fulfills the policy intent. So I suppose our question around that comes, do you believe that then is clear enough for people who may be reading this regulation about access to patients and their patient records as being clear enough?
Yes, so those 2 points, I think we think that we are satisfied from a drafting angle. We've discussed with the drafters again to confirm. It is sort of quite a technical drafting point, but we're satisfied, having discussed it, that means that it does what we need it to.
Having said that, if there's a feeling that the legislative wording is difficult and complicated for the man in the street to understand, it's not impossible at all for guidelines to be issued so that it's very much more in a language that people can understand, and it can be outlined in fairly comprehensible way, what access you have and when you should expect it. But obviously there will be some restrictions, obviously mental capacity, age restrictions and things like that. So just to sort of safeguards to make sure the wrong people don't get hold of records as well. But yeah, we feel it's really important for people to be able to access records for people they're responsible for.
Would those sort of guidelines be something that you'd be issuing as the Minister for Environment, or is that something that would maybe be encouraged to be produced by the Care Commission?
It may well be produced by the Commission, and I'm sure they would want to get the wording right, but as the Minister with the law under his responsibility, I would imagine that I would certainly have to approve them, and it would probably be me that would issue them. And at the end of the day, provided they did what they said on the tin, it's not really important if it's me or the Commission. It's going to come from our side of the fence, and it would be for people to read and understand, hopefully.
So I suppose that the final point to clarify around that is the policy intent in itself. So in these particular ones, it was to intend for the openness and ease of access to records and to patients in cases where it is absolutely appropriate.
Yes, so the intent is largely to enable the loved ones of patients to be able to access care records. Clearly, and not just patients, that's also care receivers in care homes and others. Clearly, there are cases where that's not appropriate. It may be that a child is in a children's home and they're subject to a care order, so the law is meant to be the intent there, and hopefully the law is clear, and certainly everything we understand it is clear that that's not appropriate to provide that access. And also, that if there are sort of genuine concerns, but largely the intent is that if a patient wants their loved one to see their care records, that is they should be provided with that information.
I'm going to move on around the governance of the Care Commission. And Minister, can you please describe your accountabilities in relation to the proposals under the draft law?
My responsibilities under the law will be as Minister with the Cabinet, covering the Care Commission and making sure that their work is done properly. Other ministers the Health Minister will have the responsibility for the hospital, and that's been a subject of some discussion. I know there was some suggestion that chief officers might be the ones held responsible, but certainly we've taken the view that that is too much, and that ministers as corporate souls should be the ones responsible for the departments they oversee. Now, obviously, chief officers can be responsible for the performance, but the minister needs to be responsible for the department. But as you might expect, as a corporate soul, the minister won't be sued or won't be taken to court as an individual and won't be liable individually. But I think we've always felt it was very clear that the minister should be the one as a corporate soul to take the responsibility. So my job is to liaise with the Care Commission through the chair and the chief executive with assistance from Francis, and to oversee and make sure that they're doing the job that the Assembly wished them to do. It's a slightly different role to any of my other parts of my department, and I'm a little bit further away from it, if you like. But it comes under my remit, and I work through the chair, the chief executive, and Francis.
So you mentioned, you touched on the ministers now becoming the accountable person rather than, or as the corporate entity, rather than the chief officers of the department. Do you foresee that offering better lines of protection for members of the civil service, or is what's?
I'm not sure, but yeah, I mean, I'm sure that's the right. I mean, I looked at it slightly differently, and I felt, and I think we felt that to put this responsibility on a chief officer on top of all the other responsibilities that the chief officer might have, could actually act as a deterrent to good people applying. And we also felt that when you look to the UK, it's trusts that are held responsible and other corporate entities, and Francis will have to help me here, but it's only right that in Jersey the minister is responsible as not as an individual but as a corporate soul. Don't know if you want to add anything there, Francis.
Yeah, I think that covers it largely, unless there's any clarification. Yeah, is it?
Because ministers have the ability to delegate functions of their ministerial portfolio, but this would not be something they would be allowed to delegate.
So the ultimate accountability as provider would rest with the minister, but they'd be able to delegate the day-to-day functions of managing the provider commission, provider regulator relationship. So it's
well, a bit like I said. I mean, the chief officer will be responsible for performance, but the minister is the person with the liability, if you like. And if the performance of the department fails to such a degree that there's a really serious issue, well, it will be incumbent on the minister to deal with the chief officer who is responsible for the performance. I don't know if I'm explaining myself right, but the minister can remove his chief officer, but he doesn't mean to say he's not. He will, or the minister will be the responsible person. Well, yeah.
It's important to emphasise that this carries criminal sanctions. That it isn't civil penalties. So to criminalise a chief officer for things that may not actually be inside their control is that because a lot of these provisions carry requirements to really inject some money to deal with it. So if your premises aren't up to standard, a chief officer wouldn't necessarily in a hospital have access to the funds. Those funds are granted by the Assembly ultimately, and so even a minister couldn't necessarily fund those funds. And clearly there's tests, and it's not about criminalising. That's not; those are ultimate sanctions. No one's ever been prosecuted under it, but nevertheless, it's obviously a real deterrent for an office holder to come in and realise that they're responsible for running the hospital. And if things go wrong, they could be personally held criminally responsible for that. So it's the same way in care homes. It is the corporate structure that runs a care home that registers. So if it's a charity, it's the trustees as a trust, as a charitable trust, a board of governors of a charity. If it's a company, it's the board of the company who would be reliable as a corporate entity. So it's akin to that because the minister as a corporation holds the legal entity. So it's felt that that's a change that should be made.
Does that work if we don't have corporate manslaughter in Jersey? Because we don't have a criminal offence to recognise as corporate manslaughter.
So this would be entirely separate to any decisions relating to gross negligence, manslaughter, murder, those other criminal sanctions. The Care Commission would look at the standards and requirements regulations. If they found breaches, the first step that they would take and that the law encourages them to take is to issue an improvement notice. And then in that improvement notice sets out the timescale that they expect the nature of the improvement they expect, the timescales that they would expect it to be made. And it's only after that had potentially been failed to be met that they would then look to provide evidence to the Attorney General, and ultimately prosecution decisions would be the Attorney General. But I think if you heard from the Care Commission, that's not necessarily that, they're looking to help services improve. That's the ethos behind this, but those sanctions are nevertheless important. And then other matters, so in individual cases, if it had been found to be another criminal matter, then that would go straight to the police. And so serious, if they uncovered in any regulated service evidence of sexual offences, gross negligence, manslaughter, murder, those sorts of things, then that would be a matter for the police.
Okay. What engagement and discussions have you had? Because this redraft of the regulations also splits out the Minister for Children and Life and Minister for Education and Lifelong Learning. What engagement have you had with these ministers about their new responsibilities?
Francis is going to have to remind me. I can't remember speaking to either of them directly, but I'm
So we have consulted them, and so in terms of the so they will take on those responsibilities. They're content from our consultation with them that they're content that they would take on those responsibilities to provide the services that they are ultimately responsible for.
Can I just ask a very quick follow-up on that? Does this bake into the law the split between the Minister for Education and the Minister for Children? In other words, if those positions were ever to be merged back into a single ministerial function, would it become something that would require an amendment in this law as well?
My understanding is that you would be able to deal with that by an order under the States of Jersey law. So I think that would be covered. It was more of a challenge to insert another minister, although I think that still would have been possible. It was just something that wasn't quite, it was a straight change rather than a change and an addition that was made. So we just tried to remedy that.
Thank you.
So moving on in the sense of registration of large services, how have you communicated your expectations to the aforementioned ministers about the structures that need to be in place to deliver operational performances and effective services?
Well, again, Francis, you
Certainly. So
responded to those two ministers.
So we've spoken to them, and the operational decisions would be delegated to the ministers about how the services will be split up, and ultimately be for the Care Commission to decide how it's done. So we imagine that it would continue while the ministers hold responsibility as providers. The actual conversations take place between their senior officers and the Commission as to how those services split up. For children's services, it's already set up, and largely these issues have. So the reason that we put in place these provisions for the large services was it was learning from that position. We recognised that the structure under the law was quite designed for smaller services, so care homes, that sort of thing, provider, manager, you'd have one of each for those services, may not necessarily be appropriate, and also the law allowed the Commission to ask for multiple applications for more than one site. So clearly, if you've got a children's service, you want to be able to register that whole service, all of its sites in one application, and you need to be able to map that service and provide appropriate managers. And so that law bakes in that flexibility. So the way that the minister sort of communicates that is, and we've been clear that the managers need to be of appropriate seniority, because that was something that was raised during the consultation, but ultimately it's a decision for them. But I know the minister was clear following the consultation that, and was put in the consultation report from that feedback, that we don't want there to be fragmented management within services, while it's a decision for the Commission and for the services to come to an agreement, and ultimately for the Commission to decide. And I think you heard from the Commission, they understand managers need to be at a high enough level so that there isn't fragmentation within the system, and lower level managers think that they have responsibilities and then say to the service, actually, no, my responsibility's here, and that then creates tensions. You need to have the managers at strategic enough level who are working in concert with the provider, which would be the minister and their senior officer.
And at the other end of the scale, these changes are going to allow us to deal with individual care providers at much smaller context. So single care providers can be dealt with, their managers can be dealt with. If the manager and the care provider are the same person, going to be dealt with, it can be split up. So whether it's large down to the small, we feel the changes are appropriate.
Okay. You mentioned in that response as well about some of the activities being the responsibility of the Care Commission to decide. But I suppose, what responsibilities do you have in confirming the full scope of what's within regulated activities, and how much of that falls to the Commission?
Well, the Commission will always will always look to the UK, I guess, to see what and how they do things, and they will suggest to me this is how we might do it, this is how it's done elsewhere, in the normal way you might do consultation. So I presume that we've looked at best practice elsewhere and are following where we can, bearing in mind that Jersey's a small jurisdiction.
Indeed, yeah. So it's very much the law is is as clear as possible as to what the services for certainly the minister thinks should be in scope of the law. It's always difficult when you're defining those services. There's a danger you capture services that you don't intend to capture. There's a danger you don't quite capture the right ones. So getting those definitions right is a challenge, particularly trying to take the phased approach that Jersey's decided to take, which is not a bad approach to take, but it does mean that you can't overnight just suddenly copy the UK law. But then once that's defined, there are services that are on the edges of some of those definitions. I'm not. There's potential with the ambulance service one. Potentially, a hospital is pretty clear cut, although services that do end up providing inpatient care may well end up finding that they're a hospital, even though they don't think that they're a hospital. So that's a challenge potentially with that definition. But when it comes to practice, the Assembly ultimately, however it chooses to adopt this, will set out what it expects to be regulated, and then the Care Commission, on a case-by-case basis, will look to police that.
You just mentioned the ambulance there. Where does patient transport services fit in this?
So that's a very good question. The patient transfer services are generally provided by the hospital. So if they're provided by the hospital, they will be covered under that. We've got a special category under that.
Having said that, ambulance services also provide patient transfer
transport
They
services.
do. So if
Quite often, somebody who's taken to accident and emergency, if they don't have an easy access back home and their taxi isn't called an ambulance, a proper ambulance, no offence, but
Yeah.
a paramedic ambulance may well take that person back home afterwards.
Indeed, and so the ambulance would be covered for that as it part of its regulation. So it will be regulated for that. But then if it's a patient transfer service, say off island to the to Southampton, then nurses that fly with them or that accompany them, they would be regulated as part of the hospital service. Ambulance that transport them would be regulated as part of the ambulance service. And then the air ambulance should be regulated by the UK authorities but the care provided while it's in Jersey would be regulated as part of the hospital service.
Okay.
So it's
Yeah, and the nurse that travels with whoever travels with the person who's being transported to the UK on the air ambulance service would also be regulated under the hospital.
Okay. I guess it's really important, isn't it, that regulation doesn't get in the way of flexibility as well, in the way that you've said, a paramedic might drop a person home afterwards. You wouldn't want any regulatory activity to actually make the system more complicated than it is already.
Yeah, absolutely. And how that's done is, the Commission has a lot of scope, obviously, and that's how you have to do these types of legislation, because you've got to cater for a lot of eventualities and provide the regulator with that scope. And it's not anticipated to prevent services from doing things. It's there to say, if you're providing this service, these are the standards you have to conform to. So is the transport you're providing appropriate? It's not necessarily a patient doesn't need to be in an ambulance if they're just being transferred back home necessarily and everything's fine. If they were then requiring an ambulance to be used, that would be in the Commission's remit. That would be when we would, the Minister might want to have a discussion with the chair about the appropriateness of their standards. But, we don't have those concerns at the moment, I don't
No,
think.
but we talk about the potential to restrict services. We do have the power in these new rules to actually do that very thing. We will be able to stop certain services being provided to certain groups if it's felt appropriate. So I think the example we used was, it may be that we would like to stop certain types of cosmetic surgery being given to people under 18, for example. But that's just an example. But there are powers in here to restrict services where we feel that it's appropriate. But that's not quite where we're going. If we do think it's appropriate and things need to carry on, we want to be common sense and allow them to continue. Clearly.
So my final question for my area, my first area, is about the enforceability. Obviously, Article 14 allows the Assembly to make, with powers to make and amend regulations to require care services to provide services that conform to legally enforceable standards. So, Minister, are you confident about the legal enforceability, and also have you consulted with the Care Commission about potential risks to the enforceability of the laws?
Well, I'm confident that we can enforce. Certainly, we've been a long time getting ready, whether all the hospital or the ambulance service, but most especially in this case, the Care Commission. They've been preparing, they've been given funds to prepare, and I would imagine that they are prepared in that way for all eventualities, including enforcement if it's required. I don't know if you want to add any more there, Francis.
I think that largely covers it, Minister. Yes, I think, with everything with our discussions we've had, is that the Commission, it is for the Commission to enforce under the law regulatory matters. It's not a police matter. We're very clear on that. And if it does come to finding evidence for prosecutions, but as we've said, that's not the intention behind this. The intention is for the Commission to support improvement, which I think you can see from the Children's Services reports. There's a real progress being shown every year in there, and that's what we would, hopefully that's what the objective of this legislation is there to do, to support those services that work really, really hard and provide a great service to continue on that path, and to shine a light where things may not be going to well. It's not there, but obviously you always need a sanction under the law, and we're confident that would be enforceable for sure.
So moving over to Helen.
Yeah, thank you. I had some questions about new regulated activities. I think some of them you have answered, and you alluded to dentistry before. The Jersey Care Commission themselves said that dental clinics and services provided by the hospital should not be regulated until all the dental services provided in the community were regulated. And we were just wondering if you can explain where you differ with the Care Commission in relation to that, and that you're going ahead to regulate hospital dental services.
Over to you, Francis.
So we made the decision that it would be that we understood where the Commission came from on that, but we felt that to create a gap around that in the hospital, the intent really is to cover everything that Health and Care Jersey do. It's so once you're captured by that hospital definition, you're then your services are regulated basically. So Health and Care Jersey are hooked into that definition. Then it's very clear for them the services that they provide are regulated. The healthcare services that they provide, and that includes the mental health services, everything. That then makes it really straightforward for them legally. If we were to split off the dental services, we understand that would mean that the Care Commission has to do bespoke standards for them. But if we didn't, if we excluded them from that, then there's a danger we'd exclude more. And again, it comes back to that: why did we regulate the ambulance at this time? We don't want to have that gap where patients actually say, raise a concern with the Commission. The Commission says, well, we can't look at ambulance service. The same way dentistry, where, is surgery on, is oral surgery dentistry or not? I couldn't advise the Minister in all good conscience that we would have cleared that gap. So that's
Yeah, I think the issue was around general dentistry. I think
Yeah.
Jersey's quite unusual in that most general dentistry is done in the community, whereas we still offer a general dental service. So it was just you've explained why
Yeah.
you're doing it, but it's not so much the surgical side of the dentistry as the.
No, exactly, and it's provided by Health and Care Jersey. So where we have made an opt-out as effect in the law is for the out-of-hours GP service that's at the hospital, and that's because that's not provided by Health and Care Jersey. It's in the hospital, but it's not. So that's the one exception we've made,
Distinction,
and we were able to carve that out quite satisfactorily, whereas we didn't think we could carve out dentistry at all.
In the same way, the cannabis prescribing, if it's done in hospital, it's got to be covered. Private practice outside of hospital is not covered at this time, although it's on the list. Dentists will be the same.
Yeah, thank you. Did you do any consultation with any of the regulatory bodies around the, such as the General Dental Council, about the decision to regulate?
Not specifically, no, not on this. I mean, we are engaging with those bodies to do with another piece of work, which is falls under the Health Minister's remit, regulation of professionals. But not on this, because dentistry is regulated in this way in the UK. The service is. We don't currently, the Minister, I don't think, has plans at the moment to regulate dentistry, but that doesn't mean that it wouldn't be appropriate necessarily if the Assembly was minded to support it for dentistry to be regulated. We haven't gone around and looked at the specific areas of the hospital. It was decided that we should regulate it all and regulate Health and Care Jersey services at this point, and largely. Because of the legislation is based very heavily on the English Health and Social Care Act 2008 regulations 2014, they're already in place largely. So it's just really a question of, is it proportionate or not to regulate them at this point? the Minister decided it was for the reasons I've outlined. Yeah.
Thank you. We've talked a little bit about prison health services and the medicinal cannabis services. Again, it's a consultation question. Did you consult at all with the prison about not pulling them into the regulatory regime at this time?
I'm not aware that we did, but as I said, we are aware that the prison service is covered by another independent assessment and inspection on a regular basis, and there's a certain amount of care cover that is done under that, but it's another one that would be on the list to potentially do in the future, but I can't say. I mean, given the fact that they're already inspected, I have to say there may well be other services we would want to regulate before we go there, but we will have to see.
But the reason we were asking the question is that obviously some of the services that are provided at the prison will be provided by Healthcare Jersey
Yeah.
and their staff, so it was just trying to understand.
Yeah, exactly. And then there's some services that are GPs, so it's
Private dentists,
and
yeah.
private dentists. So, given that complexity, it was largely a decision that we reached with the Care Commission. Although we did map what the prison healthcare service looked like when we came to planning it. But it was largely a question of could the Care Commission, how did it envisage doing that? And it was decided not at this time, but it certainly doesn't preclude it, as the Minister says, from being regulated.
Thank you. In terms of medicinal cannabis, prison regulation, etc., have you got any time frame at all in your thinking about when you might bring forward those initiatives?
I don't, and the reason I say that is, as I said a little bit earlier, I think it's fair to say we had hoped we might be in this position 12 months ago, and for various reasons we haven't, and we're here now. We're very close to elections next year, and I feel it would only be appropriate for the new minister to decide where we go next with this. But the important thing for me was to make sure that the previous government's work on this was carried on and enacted before the election. So the decisions were taken as to where we were going: hospital, ambulance, inside the hospital, no bits and pieces outside, and then you concentrate your work on that. You try not to think too much. I mean, this is a big piece of work, and it's taken a lot of effort from Francis, the team, and the Care Commission, and everybody. In fact, they've all had resources to prepare. This is the big one, if you like, to get over the line, and then we move forward. But the most important thing was the decision was made: hospital, ambulance, concentrate on it, get it done before the election. Forget about putting any resource into thinking about others until we've got this over the line.
Okay, thank you very much.
Had we been here 12 months ago, it may well be a different decision. But certainly I know the Health Minister shares my concern about medicinal cannabis prescribing in Jersey. There's a lot of stats, a lot of things that need to be sorted out there, and it would have been top of my list. But we certainly don't have time now until later next year.
Okay, thank you.
I mean, do you think any of those work frames you've looked in, like do the general dentistry, the prison, and the healthcare that's provided up there, and then maybe, obviously because pharmacy is included in the regulations, that actually some of this might be quite easily transferable legislation to community dentists, the prison and cannabis prescribing, or do you think it's a bit more complex than that?
I think it's always easier once you've got the baseline piece of work done to pick and choose and put some certain sections, like, as you say, we're going to have some work done around dentists in the hospital. That can only be of assistance. I guess it will be slightly easier, but in certain sections, we will have to think hard about where we go. Yeah, we'll have to see.
I'm just curious, before I come to my questions, to follow up this point about there being a 12-month delay that you would rather not have had. Was that driven because the work was more complex than you thought, technically, or was it driven by a degree of what you might call political opposition in the broadest sense?
I think it would be fair to say the delay started off because the Health Minister indicated that he was uncomfortable with the way this is going, and I think it would be fair to say that right at the outset he was very worried about the effect it could have on his department. And I spoke to the new incoming, in fact he was still the incoming chair at the time, about how we might move this forward, and he was the new chair was very keen to press upon me that he saw this as a great opportunity to help the health minister and the hospital, current hospital and the new hospital, with his experience and the way he wanted to move things forward. So I then took that to the health minister, and the health minister and the new chair met and had a meeting, and health minister was very much more reassured after that and a lot more comfortable. Further, we had a few little amendments, things that we had to change. I can't remember what they were, but I remember we did have some.
Yeah.
And we find ourselves where we are, unfortunately. It does seem crazy that it's taken 12 months to get from that position. I don't know, have I forgotten any other reasons why there was delays, Francis?
No, I don't think so, Minister. I think, as you say, these are fiddly amendments, just by the nature of defining what a service is, what is a healthcare service, what is a hospital. So they're always challenging in that regard, because we've taken this phased approach. So that definitely contributed to the time, just the nature of the process.
Well, we have the health minister tomorrow, so we shall get his take on it from that. Can I move on to some slightly narrower questions, just to cover off a few items? One of the changes is to do with term limits. So you've put in changes around those, and the disqualification of commissioners as well. Are you worried that they might put off people from applying for those roles?
I think one of the concerns over the terms of office of commissioners was around the fact that it was possible, and I think we almost had an example of somebody who'd worked almost in their nurse days for the hospital, and many years later in a position of massive experience, offering themselves as commissioner, but because right at the start of their medical career they had an association with the island, they were disbarred because the rules say no connection. So we felt it was more appropriate to introduce this 9-year rule, and provided you've got a 9-year period of not being involved and you qualify and it's felt that you're suitable, you can qualify as a commissioner. I can only see that is a benefit to us, because if we're excluding really good people who for some reason very much earlier in their career have had an association with us, that would be a shame.
And the term limits for commissioners, where did that come from?
So that just rounds the loop for the Jersey Appointments Commission guidelines, say 9 years as a maximum term limit for these types of offices. And really, we felt that it should be in the law, so that was clarified, and that certainly this sort of CNAG has flagged up at times where that's not been in the law.
It's a tidying up, and the previous chair served 9.
In fact, the inaugural chair just completed an 8-year term, and they left. They wanted to leave early, in fact, there was there's not been a problem with it.
Okay. Moving on to duty of candour. I wonder, first of all, where the changes around duty of candour, where the principles that you're putting in around duty of candour came from. What was the motivating thought behind these changes?
Well, I think the first thing to say is that I think it's really important that employees have the duty of candour, and they say sorry when they genuinely mean it. They explain why things have happened in the way they have, and they show how mistakes have been made. Jersey law doesn't currently cover that, and depending how the expression of being sorry is expressed, it could end up in court as a liability, and say you could be seen to be admitting your liability. And I think we felt that it's really important to bring in the rules from outside, which say staff must say they're sorry. We want them to say they're sorry. But they must explain what's gone on, they must explain the mistakes and how that's happened. But equally, that does not preclude in any way people taking the hospital, the minister, whoever, to court or legal proceedings. But I just personally feel it's really important that people express some sort of apology and say they're genuinely sorry, because mistakes happen, and you very much hope that any mistakes that happen in hospital are genuinely mistakes, and people should apologise, and we want staff to be able to apologise.
I guess the controversial bit around this is not being able to use the duty of candour in a legal setting. What was the thinking behind that?
That follows other.
Just trying to understand the question. Not using duty of candour in a
So
legal
the
setting.
rules, as I understand it, say that you cannot use the duty of candour letter.
The wording of the law says that it's not submissible.
Current law or the new law?
draft
The
law
draft law.
says that it's not submissible as evidence in legal proceedings.
Yes, I mean, I think it's important that all the evidence, that we have some sort of awful case that happens, want staff to be able to apologise. That letter doesn't need to be admissible in court, because if something terrible has happened, there will be a huge body of evidence which has been investigated, which will all be put in front of the court. And I don't see that the letter, the duty of candour letter, makes very much difference in that way or form, because the investigation will happen, the evidence will be clear, and that will be put in front of the court. Have I got that right?
Yeah, absolutely. So yeah, to be clear, it's not admissible as evidence of an admission of liability. So it's not necessarily, that any evidence in relation to a case is admissible under the rules of court as they stand today. So we'd be talking about negligence generally, which is not, this legislation does nothing to affect tort law, negligence. They would, the court already has its long established rules on what is and is not admissible as evidence. All this says is that letter that's issued, that's got the apology, details all the facts, it's not admissible as evidence of liability. So it could be used to say, well, the hospital said they did this, they did that, they did the other. Could use it that, but you can't say, look, they apologised. They're saying that this is then admitting liability. The law's very clear. You can't use it in that way, and the principle behind it is that behind the duty of candour is open, honest transparency, and encouraging. And in those cases, you won't see many in court, because they settle. You want cases to settle. Things do go wrong in healthcare. It is not that is not necessarily, that's not malice. It's not that things go wrong, and often it is not negligence. Often it is actually a reasonable body of practitioners would have done this. Something went wrong. It's not negligent, but still payments are made, or in all settings. So you want to have that openness and transparency when things have gone wrong. Apologies, settlements can be made, things can be moved on, and that is part of the process. And the duty of candour first came about in England following the Francis Review of the Mid Staffordshire Hospital in 2014. The very clear recommendations on that, and the more we can make that effective, and it's not always been that effective because of how it's being used. And some of that is because of the protections for apologies in English law aren't as clear for this liability point. So that still makes them reluctant. We want all services to know the liability. It is not an admission of liability. May still be liable. There may still be lots of evidence of liability, but that is not evidence of liability.
So, but it is the case, isn't it? In the UK, they can be used as admissions of liability.
So apologies can't, but the letters, they're not saying that the letters can. So the Compensation Act in England is worded differently. It isn't as clear on whether the letter could be. It is saying apologies are not an admission of liability, but they don't say that they are not admissible as evidence of liability, if you see what I mean. So the law in England effectively says they can't be construed as such, but this just goes further and says they are not admissible in evidence as evidence.
So this could be a very technical point, but what you're saying, I think, is that it cannot be used to say you're wrong here because you've clearly admitted it, but it is admissible for the purposes of saying when you add up all these things that you've put in this letter, in our view as a claimant, that is an admission, and then it becomes a negotiable point basically, as opposed to it is definitely an admission.
Yes, so I mean, so you could use the evidence in a letter to find other evidence to say that to say they've documented that this happened, and then you would go through the different points within negligence and say, through
Is it negligence or
here,
not?
are they liable? And then it's for the court to decide, obviously for the judge to decide on the balance of probabilities based on that evidence provided. So, but it is what this is saying is that the judge can't just look at the letter and go, they said they're liable because they've apologised in this letter. So they cannot do that.
So it's the word apology that is the thing that cannot be used.
To that extent, I mean, it may be the case that that they would try to use it and that there would be an argument in the parties, but they would almost certainly the letter would be brought forward as evidence, and then there would be an argument about the status of that letter. And how it should or should not be used in that case, but the fact is it would be still disclosable, but it cannot be used as evidence for the liability point.
So and the central reasoning behind that is that you want to encourage open admissions, and you worry that if the duty of candour could be used, then it will restrict what people say in those letters, those admission of candour, duty of candour letters, that it will make those people far more cautious.
Absolutely, I think that's absolutely right. And a mistake or something may happen in hospital, and people may, the relatives may go in, or even the person affected may say, "What's gone on here?" And the manager or whoever will be in a position where they will want to say, "I'm sorry," but will be terrified to, because the next thing they know, they're in court. They will want to say, "I'm really sorry what happened. We were doing this machine broke, or this drug was administered wrong," or what have you. But they will say none of that, and then the patient will be hugely frustrated and upset because the department will say nothing, because they will be concerned. This allows them to say they're sorry, to explain basically what has happened. As Francis said, if it's a machine or a drug, there will be hopefully another investigation into that, and that will be a body of evidence that will come forward, and the drug evidence will come. There will be a pile of evidence here and a letter here. Just because the letter is not an admission or admissible, there will be another body of evidence will be forming the court case if it goes to litigation.
What about seeing it from the point of view of the person wishing to pursue legal action? Is there not a risk that they will see this as an attempt to lessen the grounds in which people can be held responsible? Because something that looks plain and simple to an ordinary person as "you got this wrong" will not be admissible in that way in the court.
Well, it would seem to me that if there is a body of evidence that's come forward and the case is clearly proven, that we get to the same conclusion by a different route. But I think we go back to the original thing, which is where we want people, and not just in hospital, in other forms of government, what have you, we want people to say they're sorry, to explain why things have happened, in the hope that things will get better. In this particular case with the hospital, where it will be quite serious and we might end up in court, we just want to make sure that people we would want to say sorry get to a point where they say, "I don't want to do that. I'm sorry, I can't say anything to you. I'm terribly sorry." No, they won't even say that. They won't say, they will just say nothing. They say, "I can't say anything." A no comment interview almost, if you like, where they would desperately be wanting to say to the patient, I can't apologise too much about what's happened here. This happened or that happened. I think it's really important that people can have a duty of candour to patients. Absolutely.
And I think the other point here is that this is saying you must apologise. So,
Yeah.
And if Jersey law is silent on the status of that apology, and yet you're requiring them to apologise, and if Jersey law, you can still, in this case, say that apology could be construed as an admission of liability and could be used as such, then every time somebody apologises here, then there's potential to say, admission of liability, and then every point is argued, is it or is it not? Is it or is it not an admission of liability? What is the status of the apology? So it would be sort of irresponsible to introduce this duty without clarifying what the status for the apology is, and the purpose is to create that openness and transparency, and there will be much more evidence. And this applies to care homes, home care. The duty applies to all of these services, not just government services. And in all of these cases, you want them to be open and honest and transparent, and for that information to be shared. So I think having that clarification is an important point to enable them to then use the duty. Otherwise, there would be real reluctance to use it, I think.
And it may just be that, somebody may wake up from an operation and feel a particular way, and it's important that somebody can say, I don't know quite what's happened here, I'm really sorry you feel like you do, we're going to find out. But it's all about empathy and trying to help.
Okay. I'll move on from duty of candour. A couple of questions on access to visitors and access to care and health records. Article 41 of the draft law amends some earlier regulations, the 2018 regulations, as these currently provide that the registered person is responsible for considering whether it is appropriate to allow the service user's representative to access their personal plan and care record. And I'm just trying to get at how this change will improve patient rights to access their care records.
Well, going back to the first point, which was the visitors and the access to visitors, I think it was clear to us that during COVID, obviously for the obvious reasons, there was a sort of a lockdown. We know there were a lot of people in care homes who got really upset because they couldn't be visited. And I think sort of post-COVID, there was a certain amount of, how do we say it, it certainly made life easier for some care homes if people didn't visit because they had less to do, less organising to do. And I think we want to make sure that we don't get anywhere near that situation again. We want to make sure that if visitors are restricted, that is recorded and the reason is recorded and it's clear why it's recorded. Because it's only right that people have access to their children or the doctor or a lawyer or a nurse or what have you. So we felt that was important. Access to records is another one, and I think we've discussed it previously, but it's only right that relatives, close relatives or responsible people have the ability to access people's records where appropriate. Francis mentioned certain instances where that might not be the case, but
yes, the provision basically says if somebody consents to their individual, to their relative or loved one wanting to see their records, then that should be allowed. The care establishment, the healthcare establishment should do that, unless the carve outs from that is if they're accommodated in a children's social work service or they're cared for by a children's social work service. Clearly that would potentially be, it may not be, but it may be, because there are very many cases, but that is possible for them to withhold that. And also if an individual lacks capacity and say there's a safeguarding issue, actually, it wouldn't be appropriate for a care home for somebody who may be, deprived of their liberty under the terms of the capacity and self-determination law, and they're not, they're unsure that actually they would really want that care record to be shared. They can deny that. Otherwise, consent, if they want that to be shared, and if they're maybe they have concerns about the way that they're being cared for or treated, they want their loved one to look at their care record, be able to share it with somebody, an external third party, then that is a right for them to then see that.
What about the reverse on that? What if you've got somebody who doesn't have capacity, either through dementia or mental health conditions, but their loved ones are concerned about their care? Yes. And their ability to request those records?
So yes, so that is a potential issue if they if they're using that. It's not to say that they have to, withhold access. It's to say that it's only in those circumstances that they may withhold access. So it may very well be appropriate for somebody to see. And we've also said that if there is a lasting power of attorney or if a delegate's appointed, then they cannot deny it. The service cannot deny it. So, if there are concerns in that way, then the best thing to do is obviously to have a power of attorney, so that if anything does, if you do end up lacking capacity, then this will kick in and they will always be able to see it. But yeah, so hopefully we just had to provide that safeguard just in case.
Moving on to a couple of points that were raised by the Office of the Children's Commissioner around access to health and care records and visitors. You made amendments, I think, in response to some of those. Did you subsequently check in with the Office of the Children's Commission just to check that the amendments you'd made were whether they had any feedback about those?
Yes, we did. Yeah.
And
yeah.
that was
and,
all...
and yes, they supported the changes we made. I think the original change was too much of a blanket. It was effectively, if they're there, then they don't, then they must not share them. Whereas actually, on reflection, the minister, following the consultation, decided no, it's a gateway to allow them.
Yeah.
But also, we still need to explain their reasons why. So that's got to be an open decision. So again, if they do restrict access, and this was something that we inserted thanks to the Children's Commissioner's feedback, is they need to be able to document that and have a record of that. So the Care Commission on its inspection can find that record, see it, it'll be in their care record, and they can hold them to account for that.
Okay, good. And are there any broader implications that have been thought about in terms of patient privacy or data protection in relation to these amendments? Are you comfortable that the whole gamut has been considered?
Yes. So the powers for the Care Commission to obtain information are already in the primary law, and we're not touching those. Yeah. So we don't think that, apart from the fact that it's extended across services, we're not extending the Commission's powers. The Commission has the systems and the servers in place to handle that data, and they're already in the existing service doing that under the powers they've got. So yes, so I think we're confident in that. I don't know, Minister, if you've got anything to.
Did you consult at all with organisations that represent vulnerable groups in relation to the amendments as a whole?
So we did some consultation. We obviously put it out there, but we didn't do sort of focus groups on the amendments or anything. I think again, the Care Commission, we were aware, was going out and doing that. We didn't want to duplicate work. A lot of the Care Commission standards are the things that will really impact on people. We have the legislative framework; it's largely in place. How they interpret that is what will really impact. So we do have, we are talking to say that patient representatives in the hospital, but basically, the legislation. These are tweaks to the legislation. So we didn't do a full scale engagement on that.
Thank you. Just to follow up some questions about political oversight and leadership, really. We talked earlier, Minister, about the Minister being ultimately accountable. And it's therefore the Minister who will become responsible for any corporate breaches. But will there be any sanctions against the chief officers? And I think more particularly the CEO. What do you understand as the relationship of the CEO in all this?
Well, I think I said previously when we were discussing who would be liable, and we discussed the Minister and we discussed the reasons around that, and I think the CEO and Chief Officer are responsible for the performance of the department ultimately, and if the Minister is sanctioned because something has gone wrong and performance standards have dropped, or performance is to the point where something has seriously gone wrong, I think it's then for the Minister to sanction his CEO, Chief Officer, if you like, and ultimately the Minister could replace the officer if necessary. But the Minister has to be the one who is liable and stand up in the dock and as a corporate soul represent and take take the case, but you know, following on from that, you may say to his chief officer, I'm, you know, not happy about this, taking a lot of stick, you were responsible for this, you have to carry the can, although not legally carry the can, you're going to pay with.
Yeah, I think what we're trying to get at is kind of where that accountability sits. So, for example, when the recent health and safety case was brought before the Magistrates' Court, it was the CEO who represented the States of Jersey in the Magistrates' Court.
Yeah. I think that what we're trying to do here, because obviously that was a case, but cases, when we start regulating hospital and ambulance services, cases could escalate in size quite dramatically.
Yeah.
And I think what we're trying to do is to make sure that good applicants still apply for these jobs. We don't want the liability of having to go to court as a chief officer or a chief executive officer, if you like, as a reason for people not to take the job on. We think, especially when you look to the UK and the way we've described the trusts and what have you, it's not the CEOs that end up in the dock.
So what you're describing there is really part of the rationale for changing the accountability framework through these regulations.
Yeah.
So I
Have
think
you had that feedback from potential candidates?
I'm not sure that we did directly, but certainly I think officers, I think indicated that it might be a problem in the future, and certainly the pressure that officers might feel if they were knowing that they were ultimately responsible for the performance of the whole hospital as an individual could be quite. That's a lot of responsibility.
So a specific example then, under the draft law, if a breach occurs within the ambulance service, would it be the chief ambulance officer or would it be the CEO of Healthcare Jersey that would be gripping the bar?
Well, I think ultimately the performance would be the CEO, because I mean, I might be wrong, but it would seem to me that the civil service have a structure of line managers, chief officers, senior chief officers, what have you. But you'd get to the top of the civil, but ultimately the performance responsibility is with the chief officer.
Would that remain if the chief ambulance officer had a statutory responsibility?
so. The statutory responsibility would fall on whoever had responsibility under this statute, as it were.
This statute?
Yeah,
not
for
their own, okay.
these breaches. So the way where you so health and safety law, the reason it was the CEO was because they act under delegation from the State's Employment Board, as I'm sure you know, Deputy, but this is different because it's the service that's regulated. The employees are employed by the State's Employment Board that sits here, but the minister is responsible for carrying on the health service. The children's minister is responsible for carrying on the children's service. And then their officers are employed, yes, through the State's Employment Board and through the CEO. But the health and safety law looks at the employer, whereas this looks at the service, who's running the service, who's carrying it on. And the provider would be the minister, and then there will be managers. So it would depend who the manager is, and it would depend on who the responsibilities placed on under the law. So a lot of the responsibilities are placed on where it says registered persons. That means both of them, manager and provider. And then it would be a question of the facts as to whether it's the manager, the provider, or both who would be prosecuted. And that would be a decision for the Attorney General based on the facts. And it is possible to have, there is such thing as criminal vicarious liability as well. The tests are different. So you could face a scenario in which it was the State's Employment Board who picked up the case, even though it was a manager who was prosecuted. It all gets very complicated, but it hasn't been tested.
No, but it has been thought about, and that's the thing. And thank you for that explanation, because it's something that the panel have been kind of going around in circles, just trying to. It's always the what ifs, isn't it, in these things? Minister, what extent does the Council of Ministers support these draft regulations?
Good support now. I mean, obviously, as I said, 12 months ago, there was a concern with the relatively new health minister about what we might be doing here But with the work I've done with him and officers have done with him, council ministers are completely on board with this and supportive, as of course was the States Assembly when in 22 we started this again.
Okay. Have you received any feedback about the funding proposals for the Jersey Care Commission?
Well, they had a significant chunk of money increased not that long ago. Yes, they've had to make some reductions like everybody else has had to.
13%.
Having said that, I believe we're in a quite enviable underspend position at the moment, which would indicate that with luck the cuts they've had to make may be absorbable without too much effect. I think it's important, especially if we're going to start work next year, to get these registration, provided this goes through. You know, the hospital will have 6 months to register. That will include a lot of work involved in that registration, and then the inspections will start later. But funding, I believe, is okay. There's a chart in front of me here with the monies that were voted at the time, and as I say, they had an increase nearly £1 million not too long ago. There's an underspend currently, but they have been asked to reduce by just over a couple 100,000. Okay. With everybody else, you know, we're trying to make some cuts and save some money.
Okay, thank you. That's the kind of the view from ministers, but the chief executive made it quite clear that, you know, Jersey's got too many arm's length organisations and is over-regulated. So can you tell us kind of how you square that circle? You know, this is obviously a heavily regulated environment. Have you had a battle at all with anybody about introducing a new set of regulations when the commitment is to reduce regulation?
Not in this circumstance. Certainly I have heard the words that you've just uttered on a regular basis recently. We regulate too much, it costs us too much money, you know, with regulation comes all these costs that we have to fund. But I have to say, notwithstanding the fact that they have been party to these savings targets and will be made to save just over 200,000, I've not had anybody come back to me and say, these two sections, hospital and ambulance, are areas that, nobody's come back and said, why are you spending taxpayers' money regulating the hospital? As I said right at the beginning, I think a lot of people will be surprised to find that actually the hospital's not regulated. They would expect it to be regulated, and for a million reasons that I won't go into now, but, you know, we need a hospital to be regulated.
So presumably if the reduction that they've taken, the 13%, proves to be problematic, will you support the topping up of that in order for them to fulfil their obligations?
Absolutely. I don't think it's right to put all legislation in place and go along regulating and then find that you can't regulate properly. Yeah, people would say quite rightly, well, if you can't afford to do it, why bother to go to the trouble in the first place? So, as I say, I am confident we've got enough money to do what we need to do, but if we need a little bit more, if I'm minister or the next minister, I feel would probably have to try to find a way of getting some more money out of the Exchequer, and I'm sure they would be supported by any future council ministers. It would be silly to be 95% of the way there and not do it properly when we know how important this is.
Thank you. And I think my final question, do you feel confident about the readiness and the preparations that have been put in place both by the Care Commission and Healthcare Jersey, that they will be able to implement the proposed changes set out under the draft law?
Yes, I am confident. As I said, they've had funding. The hospital, the ambulance service and the Commission have all had funding for a couple of years now to prepare them for this to happen. I haven't heard any alarm bells to say that they're struggling for either time or money. So I must assume they are ready. We've had a delay, as we know, where it could have happened some time ago. There will be the 6-month delay, but so that the registrations can take place. That's another 6 months, 9 months probably now with the Assembly debate and everything else. There is time. I would be I would be disappointed and surprised if either of those three parties were not ready. And certainly from a Commission perspective, I've not heard that we're not prepared. A lot of discussion going on with people who might come in to help us for the actual inspections. We've looked at the cost to the hospital, and initially we were suggesting inspections every 3 years and annually for the ambulance service. We've had a lot of discussions over the implications of an annual service, where people came to us and said, you know, we spend this amount of time getting ready for our annual service, we spend this amount of time getting inspected, and we've got this much left before we start for the following year. So we've taken that on board. Ambulance is going to 3 years, hospital is going to 5.
Children's services.
Yeah, and the other thing about the hospital, we agreed to, rather than inspect the whole thing in one hit, we will chunk by chunk. So we've listened to all those concerns, and we've made changes to make sure that we can make the whole thing affordable and practical as well as anything else, because it's really important.
Will you as Minister have any influence over the sequence of the inspections?
I don't think I will, and I'm not sure that it would be right. I'd certainly have to think about that. But I think it's important the Commission are, we want our hospital services independently regulated. Okay, there's funding and there's other stuff, all this legal work has to be done outside. But once they're here, we want them to be independent so they don't feel that they're being pressurised to do anything, one thing or another. Having said that, if it was clear to me that there was a section which was performing much less well than other sections, it may well be that I'd say I'd like this done first. But at the moment, it's not being suggested.
Thank you.
Thank you. Just moving on to the last couple of questions, we are very close to the end. There is one question around the decision around health service fee being nil. Why was that decision came to?
The fee,
Yes.
well, the funding is being provided by government to the Care Commission to fund the inspections. Health Service, we've got an awful lot of things to pay for coming up, and I presume that was the reason, Francis. It didn't say there's going to be dollars going around the circuit.
Exactly, wooden dollars, an administrative process when in reality all the funding's being provided by the Assembly. So nominally having them pay fees when really they're not charged fees, it's provided centrally. We needed to just clarify that in the law, that actually the funding for government-provided services would come under the budget, the annual budget, in a specific process that was led by the Minister for the Environment to then put that case into the annual budget, and then obviously considered by the Assembly, and then the fees would be charged to other services. But they are currently all subsidised. The regulation of those services is subsidised. It's not like, say, financial services, which is full cost recovery model. There's 55% of the cost of regulating those services is paid for by fees, and 45% of the cost of regulating those services is paid for by government.
It is a slightly different model, because planning, obviously, government does pay fees for planning applications. Is there a sort of a philosophical change behind this, or why? Because it does seem like a change of the normal model, which is the government pays the same as private people pay.
It's a very good question, one I'm not sure I've got the answer to. Certainly I've not heard any suggestions that we take the hospital type model and stick it into the regulation department. The regulation department would need seriously more levels of funding from the Treasury if that was the case, and I can imagine the Treasury's reaction.
Yes, I think on this case, given that the funding was already provided and it was a bit of an academic exercise, that the fees were there, the funding was there. So why charge the fees when it's clear? And we just updated the duties and the law on that basis.
And this applies as well to children's services operated by government as well. They're nil funded.
All services that are regulated. So there's also some currently regulated care homes as well from Health and Care Jersey, children's homes, anything provided by government. The funding would still be provided. Government will still pay. It just pays through the budget rather than through fees.
Yeah.
Okay. And then the last question I have around the proposed budget. There's under the heading of other estate projects, there's another I&E estate projects funding of 1.3 million in 2026, but it's labelled as regulation of care. Are you aware of this line and what it applies to?
I'm not, and I don't. Any ideas?
It may be to, I don't know for sure, but
1.3
it may,
is not jumping out
it
at
may
me.
be to do with, but please, I'm not sure, but it may be to do with an investment in property to do with one of this health or social care services to increase standards to meet the Care Commission standards. So that may well be what it is, but we'd have to get back to you on that.
Okay. Well, we've got the Health Minister tomorrow, so hopefully if he can't shed on light on it, then we will write back to you and ask for if you're able to clarify that position. Right, so Minister, that brings us to the end of our meeting right on 4:30. So thank you, Minister, for your attendance today and for the officers for coming with us. And as I've just said, if there is anything further, we will follow up with you in writing. And again, once again, thank you very much, and I'll draw